Good morning, and welcome to Legal Beagles. I'm your host, your main host, Calvin Woods, and this is your side host, Alex Millman.
Side to some, but we all know I'm the star.
I don't know, literally nobody said that to me.
No, quite literally, I registered the star in my name. It was an anniversary present.
Oh, that's fun. What are we talking about today, Alex?
Well, today we're talking about social media, thanks very much to Israel Folau. It is something that's in the spotlight at the moment, thanks to that ongoing saga that's now before the courts, and also thanks very much to the High Court in a decision handed down earlier this week, which appears to just say that the public service can sack a public servant for what they say on Twitter. Now, you've been following the Israel Folau saga for quite some time. I'm one of those old-fashioned people who only has a Facebook to keep up with the family and not much else. There's a very good reason I haven't added you on it. Because I don't give a rat's, to be honest. But putting that to one side, you're one of these young people who's au fait with the
I do have that on
book,
you, Alex.
with the Tumblr book, the Instaface, the Twittergram. Surely, if I'm at home, outside work hours, and I'm just blogging away an anti-disestablishment rant on Tumblr, surely that's my business, and my employer should not be butting their head in.
Yeah, and I mean, it's a really good and really interesting point that we're seeing argued more and more frequently. What does the connection need to be with work? And in some ways, the recent High Court decision involving the public servant is not a very good example because there was quite a clear connection with her employment. Effectively, well, you're familiar with what she was actually doing.
Yeah, so in that one, it was a officer of the Department of Immigration posting anonymously on Twitter numerous very harsh criticisms of the department, departmental policies, government and opposition policies, and even in some cases personal attacks against the relevant minister.
Yeah, so she made about 9,000 tweets over the course of her employment, personally attacking her employer. Now, where I think Israel Folau differs for quite a number of reasons, one of which is the fact that he wasn't personally attacking Rugby Australia. But the differences between those two cases are much more distinct. So effectively, the public servant was making an argument that she had a constitutionally protected right, the implied right of political communication, freedom of political communication.
Which the High Court has repeatedly said is complete and utter bull, but...
Well...
insofar as it relates to an individual.
That's right, yeah. Well, whereas Israel Folau hasn't made the argument that he had the right to say what he said. He's made the argument that by his employer dismissing him because he said it, it falls afoul of the protection against religion that exists in the Fair Work Act. So it's quite a separate and distinct argument, and I don't think we're going to see too much crossover between the two cases.
Indeed, I also don't believe that the High Court decision, although it has been lambasted in the media for various reasons, as usual, commentators who don't know what they're talking about, deciding to talk about it and making a hash of it. But at the end of the day, the question being asked in that case was, is Section 13, subsection 11 of the Public Service Act unconstitutional? Now, that is not a question that is ever going to be asked in relation to a private sector employee, because any code of conduct to which a private sector employee is subject is going to be merely a policy of their employer, and the Constitution is not going to matter.
Look, I agree to the extent that there is that constitutional aspect that factors into it, but in a lot of ways, that code of conduct in the Public Service Act is just like a code of conduct that any employer might have. And by the High Court saying that code of conduct in the Public Service Act was reasonable in the circumstances, I think that's indicative of, it reinforces what we already know in the private sector, that codes of conduct are completely lawful. And historically, before this had even happened, there was a very long line of case authority that said if there was some sort of nexus to employment and as a result of that connection there was a breach of policy, then absolutely that's something you can discipline an employee over. So if we were friends on Facebook, and I started launching a tirade against you, for example, that conduct might have a sufficient nexus to the workplace to be able to justify disciplinary action against me, which I suspect is why we aren't friends on Facebook, because, we both know you have a big mouth, Alex, getting into fights with people on LinkedIn all the time.
I don't get into fights. I get into reasoned academic debates. Thank you.
I'm not sure that they see it that way.
Well, including with my former employer, so we'll leave that.
Well, in summing up, what's the key takeaway, do you think, from these most recent cases, Alex?
Well, at the end of the day, Israel Folau, that case is still before the courts. All bets are off on which way it will go. It's going to be a test case, but my personal feeling is that the assertion that you can restrict the expression of religion or religious views to a degree, that will be found to be necessary because, of course, if you say, no, you can't restrict the expression of religious views, where does that end? As for the High Court case, I don't believe that's going to have much flow-on effect elsewhere outside the public service, and it is certainly not as significant as your normal commentators are making it out to be.
Yeah, agreed. I think it really has limited application unless you're going on year-long tirades against government policy for government which you work for.
I do love that malapropism. It's the tirade, not tirade.
And on that note, that concludes this episode of Bagels.
He's getting out before he dies.
How was that first take?